So the question then is, how is the world's most effective regional intergovernmental organisation engaging with entities other than its member states on issues as fundamental to its own history and existence as internationally recognised human rights? The march of European leaders together in Paris in the days following the attack on the offices of Charlie Hebdo, as well as the appalling suffering of migrants trying to reach Europe's shores, all stranded between its internal borders, are two powerful reminders that human rights are no abstraction. The fortunes of European states and non-state actors are deeply entwined. Now, on today's question, how engagement between the EU and non-state actors could be more effective, it is important to start with a reflection that no one would choose to start from here. The EU is engaged in its own existentialist crisis in three major ways, which threaten its integrity and its future. These need no introduction, but let's just list them. The first, of course, is the financial crisis that has engulfed some members of the European Union, and in particular the bailout referendum affecting Greece. The second is indeed the issue of migration into the EU and within the EU that pits member states' commitment to human rights against the fears of local populations and national politicians wishing to represent or exploit those concerns. And finally, Europe's security issues have not gone away. One example is seen in the ongoing situation in Ukraine, and the EU member states from the Baltic to Bulgaria are rightly concerned about what might come next. And of course, there is the issue of terrorism and the EU's response to terrorism. If this were not enough, a second tier of challenges faces EU member states and sub-regions that are increasingly nationalist in outlook. Look no further than the United Kingdom's planned referendum on its membership sometime over the next 2 years. Human rights do not escape the gravitational pull, with the UK government committed to repealing the UK Human Rights Act and introducing a British Bill of Rights, which might recalibrate the UK's relationship to the European Court of Human Rights. Now, although the 47-state Council of Europe is certainly not the 28-state European Union, incorporating the European Convention on Human Rights into the EU itself was a commitment of the Lisbon Treaty in 2009, reflected also in the content of the EU's own Charter on Fundamental Rights, and as such, a retreat from the European Convention is a retreat from the EU itself. Now, as I said, no one would choose to start from here, but here is where we are. So let's go. I do see some definite opportunities for effective multi-stakeholder engagement in the months and years ahead. My remarks will focus on opportunities within the realm of business and human rights, but I think this field, one which many of us here today represent, is symbolic of the wider human rights non-state actor debate in the EU. Arguably, it is one of the most profound of such interfaces, raising issues across many of the EU's main policy areas, from justice and home affairs to trade, development, external relations, and issues of collective security. That's maybe why the European Union has struggled so hard to align on this agenda, one of the reasons. I'll also try to pitch the remainder of my remarks within the context of how the EU sees itself. We are now almost halfway through the decade, and Europe's 2020 growth strategy puts forward the following stall to the world, and I quote, "In a changing world, we want the EU to become a smart, sustainable and inclusive economy. These three mutually reinforcing priorities should help the EU and member states deliver high levels of employment, productivity and social cohesion. Concretely, the Union has set 5 ambitious objectives on employment, innovation, education, social inclusion and climate and energy, to be reached by 2020. Many of these objectives are significantly off track, I would say. How can better multi-stakeholder action on human rights help? First, I will make some short observations of the EU's own internal dynamics before turning to the issue of the EU's place in the world and the central role that greater cooperation on business and human rights might deliver. So the first cross-cutting issue is Europe's internal coherence, and particularly the issue of corporate social responsibility. You already mentioned, Jeff, CSR. In 1993, the then President of the European Commission, Jacques Delors, called on enterprises to combat social exclusion and unemployment. In 1996, the European Business Network for Social Cohesion was formed and later renamed CSR Europe, to create a space for men and women in business to share experiences, develop solutions and engage in smart policy dialogue within the EU with a view to enhance corporate social responsibility within their organisations and beyond. Now, the way that Europe came to see CSR is very much developed through this lens. For many years, I have been one of those who strongly criticised the EU's old position on corporate responsibility as being entirely voluntary and EU-centric. But it's important to remember that it was instigated at a time 20 years ago, in the aftermath of the Cold War, when Europe had the luxury of being inward-gazing, perhaps. Germany had just been reunited peacefully. Now, one reason for this emphasis on voluntary CSR was that many EU member states already had well-established mechanisms of social dialogue, unlike the UK. For example, the UK had been riven by major industrial action through the 1980s, but many other EU members had more consensus-driven relations between workers and management. And in some countries, trade unions sat and still sit on the supervisory boards of companies. Perhaps this is why the attack on CSR came first from the Anglo-Saxon and Celtic fringes of Europe. But the 2011 redefinition of CSR, very much in line with the UN Guiding Principles on Business and Human Rights and other international standards, was essential and was long overdue. Limiting CSR to voluntary actions makes some sense when a coherent level playing field of regulation within the EU is itself ensured. However, taking such an approach when you start to consider the interests and impacts of European companies beyond Europe in the wider world makes no sense whatsoever. The new CSR definition goes some way towards addressing such concerns, but is not sufficient on its own, in my view. I believe it remains one of the main limiting factors that restricts multi-stakeholder cooperation on issues of human rights. This is no longer the unique fault of the EU, but it is the fault of the conceptualisation of CSR itself. CSR has been attacked by business for not being core to business operations, and by civil society for the very same reason, and for relegating societal impacts to the margins of concern, often resulting in philanthropy and little more. At the OECD Global Forum on Responsible Business Conduct in Paris last month, both global trade unions and business representatives publicly distanced themselves from CSR in favour of a more normative, responsible business conduct approach, RBC. Not the Royal Bank of, that's the Royal Bank of Scotland's RBS. So. Responsible business conduct. If the OECD has now fully moved away from CSR, isn't it about time that the EU does likewise? Given the commonality in membership, if for no other reason. I know the EU has created something of a CSR industry, but this is not reason enough to continue unreformed. And of course, let me stress that I'm not condemning the good work, some of the good work, that is being done under the CSR umbrella. It is just that we've been carrying the wrong umbrella for too long. Now, I'll stop here on the CSR report. In my book, there's a whole chapter on this. I spanned a whole chapter deepening the critique in social contract terms. Hobbes, Locke, Rousseau would not have liked CSR. Kant would have hated it, really hated it. And it's therefore not surprising that many of us in the human rights field have long struggled to come to terms with it. And as well as the farewell to CSR, there are two other cross-cutting issues that we need to address if we're going to have more effective multi-stakeholder engagement. I make these comments on behalf of my IHRB colleagues and our centres in Myanmar, Kenya and Colombia, and also the grouping we have in China, and through conversations with businesses, ambassadors, NGOs, trade unions. So the second cross-cutting point then is, are human rights an impediment to European economic growth? With 50% youth unemployment in member states such as Spain, jobs are everything. We are witnessing a period in our history where a whole generation of Europeans will scarcely know the workplace for the first part of their adult lives. We are right to be concerned. For those rightly focused on growth and employment, human rights can look like a constraint, a drag factor. Now, there are a few people in this room that need to be convinced as to why this is not the case, but for the purposes of YouTube, let's be honest. There are many policymakers who would roll their eyes when reading the title of today's conference. On which cloud do those guys live on, they might think. Perhaps the Charlie Hebdo tragedy reminds us all that human rights include workplace rights, but they also include fundamental libertarian values such as freedom of expression. Without freedom of expression and the right to privacy, there can be no innovation, no creativity, no entrepreneurial behaviour. Human rights do not constrain economic growth, they are the bedrock of sustainable economic growth. We have a massive educational task ahead of us, but sometimes it is our own business leaders, such as Paul Polman or Peter Sutherland, that can help us make the case. Or perhaps it's business associations, even, that will invoke human rights in calling for a leveller playing field, whether it's on mass surveillance or privacy protections on the one hand, or recruitment agencies and their policies on another. So the third cross-cutting question is, are human rights a pre-competitive issue? The third cross-cutting point is perhaps the most fundamental of all. Is cooperation on human rights a competitive or a pre-competitive issue, or both? We really do not talk about this enough. Take, for example, the CSR agendas of some member states. I've been in China, for example, and I've seen EU member states issuing CSR guidance to their own companies incorporating the UN guiding principles on business and human rights. But the framing has been very competitive in tone, focusing on how to help their national companies promote their business abroad. Take, for example, Sweden, being the only EU member state to have a CSR memorandum with China, something I very much support and respect. This all sounds fine until you talk to the EU's External Action Service in a country like China about the EU's strategic approach on business and human rights in China, or even which CSR activities individual member states are undertaking. There's a lack of coherence. The lack of coordination, which must amuse the Chinese and other major third country states to no end, is not due to a lack of resources or capacity on the side of the EU, or not primarily that. More, it is that CSR is generally seen as a competitive issue between member states, and fair enough, until we consider the implication for human rights. Should human rights be a competitive issue between member states and countries as human rights sensitive as China? No, of course not, we might all think. Then why don't we make business and human rights pre-competitive? You'll be aware that many EU member states are developing or have developed business and human rights action plans at the current time, and much to their credit. But what about the EU's own business and human rights action plan? Until this is firmly in place, I worry that the result will be a perverse set of national incentives that will push government policy and with it stakeholder engagement to the national level and increasingly into the competitive space. There are many multinational Chinese companies that are seriously interested in business and human rights these days, particularly in third countries in Southeast Asia or Africa. So too Chinese ambassadors. Should they really be faced by a multitude of EU embassies sending different messages and issuing their own sometimes inconsistent guidance on human rights due diligence, for example? Or would they not respect more a strategically aligned approach? In other words, are EU member states themselves willing to make business and human rights, at least the bedrock of it, a pre-competitive issue? And if this is the case, will they facilitate Chinese companies, or Indian, Russian, Brazilian, whatever, to sit with European companies registered in EU member states to share expertise and knowledge and agree thresholds of transparency? So moving to the final part of my speech, 4 concrete examples where I think there are some opportunities for us. So the first example is more effective engagement in EU trade policy. Let me just offer a few examples how we can be more effective. So I said that. You will be aware that negotiating bilateral trade agreements lies firmly within the competence of the European Commission, and that the EU now has a number of such agreements, some of which make reference to human rights. Let's take, for example, the EU-Colombia agreement. The Colombia extractive sector has for a long time been associated with particular parties in the internal conflict, linked to significant human rights abuses, land grabs, pollution, abuses by public and private security forces, and also the assassination of trade union leaders. Yet the Havana-based negotiations between FARC and the Colombian government requires agreement on land and therefore some agreement on access to assets such as oil, coal, gold and artisanal mining. The fact that the EU is one of the largest importers, the UK is one of the largest importers of Colombian coal seems to be barely registering on the radar of all but a few civil society organisations here. But in the Netherlands it's a much bigger issue. And for German NGOs, it is inherently linked to global agreements on climate change, as much as the more immediate human rights concerns. So for the human rights community, which is the greater priority? That Colombia continues to develop economically and that combatants from all sides, including the internally displaced, can develop livelihoods, whether they be in mining or agriculture, or that the EU moves to a full embargo on coal imports to meet climate change commitments. I know it's much more complex than this. There's issues such as carbon capture technology, etc. But are we effectively engaging within the context of the EU-Colombia trade agreement? Are the current NGO or industry-only initiatives enough? Is there not a role for much greater European Union leadership? Example 2, maximising the benefits of the EU non-financial reporting requirements. You will be aware that the largest 6,000 publicly listed companies will soon need to report under the new EU directive. First of all, my congratulations to Richard Howitt MEP and all of those who worked so hard to bring it about. We look to the Danish government in particular and its own work developing guidance for its own national reporting requirements, in many ways the model for the EU's Report or Explain Why Not approach. We know from the California supply chain requirements or Dodd-Frank 1502 in the US that mandated reporting without guidance on human rights due diligence, mitigations and remedies will actually be against the interests of European companies. The French Parliament is currently also debating its own human rights due diligence requirement for its companies, and the British government will produce guidance on forced labour and trafficking later this year as part of the Modern Day Slavery Act. Shouldn't we be a bit more joined up on this? Is it a pre-competitive issue? And if so, where is the European Commission in all of this? It is perhaps telling that the most active leadership on the UN Guiding Principles reporting framework, or the development of human rights benchmarks for ranking companies' performance, comes from individual member states, such as Sweden, the Netherlands, or the UK, and not from the European Commission. We have great hopes that the forthcoming Dutch presidency of the European Union will address this issue. But there's an enormous opportunity for more effective engagement on due diligence, reporting, and benchmarking company performance on human rights. We're only at the start of this agenda. Over 3 years ago, IHRB helped produce European Commission human rights guidance on implementing the UNGPs in 3 high-impact business sectors with our colleagues at Shift. Our friends at Global CSR in Denmark did the same with a number of other actors for European SMEs. These initiatives set a benchmark for multi-stakeholder consultation and the production of human rights guidance, which is now being emulated by others, such as the Swiss government, for their own work on commodity trading. But what has happened to this within the European Commission since then? How often does the Commission actively promote this guidance? Now is the time for more active leadership to help EU-based companies navigate fundamental challenges, such as adequate knowledge about negative human rights impacts, the extent of mitigation that might be seen to be adequate, how much transparency is required, and what effective remedies might look like in practice. Example number 3, supply chain and third country leadership. Since the Rana Plaza disaster in Bangladesh 2 years ago, I've seen how a number of EU member states stepped up to take action and challenged the whole way the supply chain auditing industry has worked over the past 20 years. I think particularly of the Danish, Dutch and German governments. The accord in Bangladesh was important. The fact that Chancellor Merkel herself was willing to intervene on the issue of the compensation fund was even more important. A potential game changer might be the G7 statement that came from the German government last month, which clearly brings global supply chains into the human rights nexus. But follow-up will be key. An even more significant development might come next year if G20 nations make a similar statement at their meetings in China. Much will now depend on how the German and Chinese governments can collaborate for the rest of this year. But let's not forget the European Union itself is a G20 member, and should it not have more than a passing interest in this discussion? A G20 agreement on human rights in global supply chains is more likely to happen if we can all point to concrete examples of pre-competitive multi-stakeholder cooperation on the ground in third countries. I know through our own work and that of others that the European companies and Chinese companies are already engaging on human rights issues in countries like Myanmar and Kenya. But where, may I ask, is the European Union on this collaboration? We would like to see the External Action Service of the European Union as a permanent partner in such efforts. When it comes to cooperating in the United Nations in relation to proposals for a binding treaty on business and human rights, the EU does indeed play an active role. Would this not be strengthened if it also played a correspondingly active role on the application of business and human rights in practice? It's also worth noting that the European Union can set an example itself with its own supply chain. Public procurement is about 20% of GDP in most EU member states, and the new EU Directive on Public Procurement allows, but does not require, the integration of human rights into such tenders. The final example, domestic engagement within the European Union. There's been much less focus over recent years on how stakeholders might collaborate within the EU on domestic human rights issues. Part of this has been politics. As mentioned earlier, this has been the bread and butter of other EU-based institutions, in particularly the Council of Europe, and to some extent the OSCE. But it's also highly relevant for the work of the Fundamental Rights Agency in Vienna, and their work begins to show some of the possibilities. There is no higher priority in Europe at the moment than the issue of migration, and the FRA's recent work on severe forms of labour exploitation is timely, echoing our own business guidance for the European Commission in 2012. The role of private sector labour providers is perhaps the most omnipresent business and human rights issue globally, and not least in the EU itself, be it berry pickers in Scandinavia from Thailand, Ukrainian workers in Poland, Bulgarian hotel workers in the UK. The Gangmaster Licensing Authority in the UK, regulation born out of multi-stakeholder collaboration is one model, but there needs to be many more. Can the EU not help address this issue more effectively in partnership with industry, trade unions and civil society? A multi-stakeholder process based on the existing EU guidance would be a start. So to conclude, the EU has begun to move effectively towards greater regulation on business and human rights, but mainly on the issue of transparency and reporting, and not on broader human rights due diligence itself. This might come with time, but in the meantime, there's a lot that can be done to make engagement more effective. I hope my remarks have suggested some ideas for where further progress could be made. Practically speaking, there are two golden opportunities ahead of us in the next months. First, the Dutch presidency next year is a chance to re-kickstart Commission activity on this whole agenda. And second, the leadership the German government has shown over recent months on responsible supply chains provides an important opportunity to move towards a stronger role for the EU on these issues within the G20 or within the OECD. And in particular, to demonstrate pre-competitive behaviour in emerging economies. Thanks once again for inviting me today, and I look forward to the discussions. Thank you.